Trusts matter more than one might think. But it's not just the trust itself. It's all of the moving parts and the original parts that go along with that trust. We're going to break it down for you and consider this program today. Join us. Well, good morning and welcome to Consider This Program. I am your host, Joe Clark.
I'm Dean Huddleston.
Happy to have you along. Hey, Dean is one of our senior advisors in the Lafayette area, Lafayette, Indiana, that is, just in case you happen to be in the southern part of the world. We do have listeners all over. He's joining us on the show this week as we talk about some of the critical conversations that people need to have that Dean regularly has with families that we serve and that we want to be able to share with you. So trust matter more than one thing. So when we set up a trust, and we don't do it, by the way, we're not attorneys, don't play one on TV or radio, work with a lot of very, very good estate planning attorneys and involved in a lot of estate planning cases. But when we talk about a trust, there are three parts that are going to be in that original documentation that have to be set up inside of the trust. The first one is the grantor. Dean, who's the grantor?
The grantor is the person who owns the asset that's going into the trust.
So we call that funding. That's one of the things that happens. It does you no good if you have a trust and it is not funded.
Correct.
Now, this is a weird thing for me, but it kind of goes along to how I had the opening, right? You don't know what you don't know, right? That is the curse of knowledge. The double curse of knowledge is I don't know what you don't know, right? So let me say that again. The curse of knowledge is I don't know what I don't know. Neither do you. The double curse of knowledge is I don't know what you don't know. And the further you go into a topic, the more that you perceive the other person also knows that information, right? So when I first started in the industry in 87, I was fascinated by trust because I really started with estate planning as opposed to investment planning. And it shocked me the number of times people would have trust who had no funding at all. They were never funded. There was nothing that went inside of the trust. Then we went through a period of time where we would see IRAs that were funded into the trust. And, for the most part, that has been removed. And if yours is there, you should really talk to somebody who knows what they're doing inside of the investment world and the tax planning world, not necessarily just the legal world, to consider where that beneficiary designation really ought to be for your IRA. There are things that are legal, and then there's things that aren't practical the way the law plays out from the tax side. It's a whole other conversation. Today, I will hear attorneys tell people that they need to fund their assets. People will show up in our office, and they'll bring all of their stuff for their next steps meeting, people just like you. And, they'll have their 401k and their IRAs and their account that they've got established that's in their name and their spouse's name. They got the family farm. They got the house. They got all this stuff. That's what we call it. And I will look at it, and sure enough, the family farm, the house are inside of the trust. They have been funded. But the brokerage account that may have $500,000 or $2 million is just sitting there bare naked. Now, you can choose to have having a brokerage account not inside of your trust. You can do that, but very rarely does it make sense for people. And it's also one of those assets that will be probatable. So if you don't think that it needs to go in the trust, that's fine, but apply a TOD or POD designation depending what state you're in and how it works. It's usually a transfer on death, TOD. It's like a beneficiary designation. At least keep it out of probate. There's no reason not to. So the second part then, we've got the grantor. The grantors put money in. Then, Dean, you have income beneficiaries. What's that?
Income beneficiaries are anyone who's going to receive an asset of some type through that trust.
So you have two types. You have living beneficiaries that are income beneficiaries, and you have remainder beneficiaries, right? But income beneficiaries are typically the grantors. Right? So Barb and I are married. We have a trust. Something happens to me or something happens where somebody else has got to step in and take over moving things for us and managing money for us. It's their job to provide us the income that we need. We're income beneficiaries. We were already the owners, right? We can, with the trust, remember, you can put things in, you can pull it out on a typical grantor trust. You're okay to do that. Then the last thing are the remainder beneficiaries. Those are typically your kids, could be your charities or whomever. How does that work?
Grandkids. The trust is going to dictate the timelines and the amount of funds when they come out. You may tell your trustee that they can get 30% of the corpus after 5 years, and then have another 5-year period go by, and they get another 30%. You can set it up however you'd like.
So I've had an attorney listen to me on the show that called me up and tried to tell me a funny, right? So here's what I like to tell people. In my first trust, other than the normal stuff that had to be there were about 10 pages that dealt, and I was 32 at the time. There were about 10 pages that dealt with who got the money if I died. One, there wasn't a lot of money. And two, I was 32 years old. There were 2 pages that dealt with what happened to me if I were still alive, right? I think that is totally backwards, by the way, in terms of how trust documents ought to be written. I spend a lot of time on talking about fading away, incremental incapacitation. That's a conversation we'll have in another segment today. So make sure if you're listening to WIBC, you know there is more to this program than what you're getting. You can go to considerthisprogram.com and get any of our radio shows from the past. You can also go to anywhere you listen to podcasts and type in Consider This Program. But here's the deal. About 10% of people just drop dead. 90% of us, on the other hand, kind of fade away. We break down, whether that's mental or physical incapacitation. And what the attorney said jokingly is, Joe, you're going to be dead a lot longer than you're going to be alive. And I looked at him and said, that's true, but I'm far more concerned about the years that I'm alive than when I'm dead. Now, my point being, if I just drop dead, I certainly don't want a mess left behind. But in the 33 years that I've been in this industry, the things that I have seen happen where people have hurt themselves because they were unaware that they were making bad decisions, because they had begun to fade away. And we can either laugh about it and say one sandwich short of a picnic, or we can talk about it in real harmful, crying terms, which is true. I mean, I dealt with another attorney this week in getting a trademark for one of our concepts, and she said 2 weeks ago, I would not have understood a word you were saying. And I just got a hold of my dad's checkbook. And all of a sudden, some of this stuff becomes painfully real in terms of what happens. So when you originally set your trust up, your attorney's going to talk to you about funding. They're going to talk to you about how you want to get money while you're alive, and they're going to talk about who you want to leave it behind to when you're gone. But there are other moving parts, right? So people many times, Dean, think you can do a checklist on a trust and it's done, right? So what are the moving parts? Well, it's you. Dean, has your life changed since I've known you the last 7.5 years?
Only a half a dozen thousand times.
People died. People been married, right? Babies.
Houses sell. Houses buy.
Yeah. You change, right?
Yep.
Your spouse can change. Did any of your heirs change in the last? We're talking about 7.5 years. And I regularly see trusts that were written in the 90s, right, that have not been changed. So, it's 2021, right? So we're just talking about 7.5 years here. So has anything happened to your heir since 2015?
Oh, no. I've only added 2 son-in-laws, 3 grandkids with another grandchild on the way. Normal stuff.
Just basics, right?
Mm-hmm.
Has anything changed in the tax code that should have changed the way your trust works?
We've gone from standard deductions where you typically would file now to a standard deduction where it's more than what I used to itemize for.
That part's true, but in terms of the trust from the tax code standpoint, in the last 7.5 years you've been here, let's see, pro rata actually came into play prior to that. Yes. So if you're like many people out there with a trust that's in your name and a trust that's in your spouse's name, you probably need to ask somebody about pro rata. That rule in the tax code changed. The amount of money that you can leave behind based on your unified credit, or what some people would call the exemption equivalent, that's at $11.5 million, has changed. It will probably change against with the sunset provision. Yep. When you started, the maximum money you could give me every year, and that's still a good idea, Dean. You really should consider gifting to Joe, right?
Oh,
right?
Thank you.
I'll
work
you
on
could
that
give
tomorrow.
$14,000 a year. Now we all know that's $15,000 a year, and that's your annual exclusion with no strings attached. My point is, what I want you to get is things change.
Yes.
Right? So it's not just the quality of the document up front. It's making sure that you address the moving parts afterwards. Laws change. For instance, in Indiana, we didn't used to have the code for decanting, right? And as a result, a lot of people didn't put in trust protectors. The majority of trusts I see don't have trust protectors. They all should have trust protectors of one nature or another. Folks, things change. And there's a reason in our process when we do a family update. When you come in for that, if you're one of our families, you know the process. We confirm the family vision. We talk about your life after work to make sure that your income is still where it needs to be and that everything is still on track there. We go over the annual tax plan. Every November or October, we actually send out a tax planning package to ask questions to make sure that nothing's changed in your life, your parents' life if applicable, your kids' life if applicable, where it's going to change your tax code. The fourth is the good, bad, and ugly of life that's going on. And then last but not least is the legacy plan. So we make sure that everything is funded properly, nothing's changed with your heirs, nothing has changed in the taxes that you need to know about. We want to run through that process. That is our commitment to you. We do it every year, or at least offer that meeting. Every now and then it's 14, 16, 18 months because people can't get in or COVID got involved or don't want to get in. That good thing about Zoom, we can force that to happen a little bit better. You deserve that kind of attention, folks. You need people who are qualified to be able to answer those questions that we just brought up. Go to yourlifeafterwork.com, get signed up for your Next Steps meeting.